Bill Cosby's recent release after a 2018 conviction for sexual assault raises a lot of questions. Was this purely a procedural technicality, or is this a protection of one's individual rights? Today we're going to break this down and we're going to talk more in depth about your right against self-incrimination. Welcome back to Hashtag Lawyer Guys. We're here in studio, ready to go.
Ready to rock and roll on kind of a heavy topic. Don't let the cheery tone trick you.
Yeah, it's a heavy topic. And, I was talking, actually driving up here, I was talking to Rachel about this. The story itself we're using to illustrate the concept. The concept's important.
Well, the concept is critical. I mean, the concept, I think, underlies or underpins
Sure.
the entire justice system, the whole concept of the justice system, I think.
Right.
Which, frankly, I think a lot of people have this romantic notion of innocent until proven guilty. But then when it comes down to it, say someone is, a big time drug dealer to little kids, right? No one wants to be supporting a drug dealer who deals to little kids when he's clearly, based on what they've seen before a trial starts, guilty. But at the end of the day, our whole system is premised on the fact that he gets a good defense. Because if he doesn't get a good defense, then what's the point in the justice system, right? And then they can get overturned and all this stuff.
That's the argument that we have all the time is
us or you and Rachel or the world?
The world.
The world, okay.
And I say us, I think it's kind of the lawyers that understand this stuff and the people that talk about it like you and I do and the world. Because it's a balancing act. We've got to protect people's rights, and those protections apply equally to the accused, the unaccused, the innocent, and the guilty. Everybody gets those same rights. And that's hard to fathom sometimes when you're dealing with a sexual predator or you're dealing with a drug dealer or someone who actually does commit the crime. The problem is you can't say, well, if they're guilty, they shouldn't. Those rights shouldn't apply because who's determining if they're guilty? Well, then you're in a spiral here, and you're not able.
So you're saying society is saying that you're guilty. Well, I mean that's not a jury of your peers.
Right.
That's society, and you only see certain parts of the story. You're not in a courtroom. You're not, hearing carefully balanced versions from the prosecution and from the defense. And so, I mean, at the end of the day, you hear one story in the media, but it's so, so important to have an actual trial with a good defense team. Absolutely. And I think that your point right there about the media, we know this, not even talking about criminal things or criminal trials, but we know things get taken out of context. Oh, 100%.
And that's part of the reason the right against self-incrimination is so important, is that in the courtroom, things can get taken out of context and from an interrogation, from a deposition, like what happened in Cosby's trial, or anywhere else. They can get taken out of context and be used against you. And if we don't have that protection of that self-incrimination under the Fifth Amendment, well, then all of a sudden now you're allowing the prosecution to kind of manipulate the story to make you look more guilty or make you look guilty when maybe you weren't.
Yeah. And just for people to know, I think it's really important too, the way the Fifth Amendment works is different in a criminal setting than it is in a civil setting.
It is. And we're going to dive into that because it is important. A lot of people don't think about that.
Which is wild. I know a lot of people will say, well, I don't want to say anything bad about myself in my car wreck case, so I'm just going to plead the Fifth. I'm like, what? It doesn't work that way. Right. It doesn't work the way you think it works.
Right.
What's your favorite quote from Princess Bride?
These words you keep on saying, they do not mean what I think you think they mean.
Yeah. Exactly.
So the Bill Cosby story, let's just kind of break down the facts real quick. He was convicted in 2018 of aggravated indecent assault in Montgomery County, Pennsylvania.
What does that mean?
Well, from what I could tell, because again, it's a different state, different terms and everything, but the idea is that it's rape.
Okay.
That's what it is. It's rape. That's the common term. It's sexual assault. And that can be with actual sexual intercourse, or it can be with touching, someone's genital organs, those types of things. So, I don't know what happened with him specifically, what specific factual allegation it was, but that's the umbrella. That's the umbrella, exactly.
Of facts that it could have fallen under.
Right. And so he was sentenced to 3 to 10 years plus fines and court costs. The reason it's 3 to 10 is because he appealed this before the sentencing hearing.
Okay, I was about to ask, 3 to 10 years seems pretty low. Now, I understand a lot of times violence against women crimes tend to have a lower sentencing rate than I think a lot of people think they do. So I was actually curious about why it was only 3 to 10.
Yeah, and one thing I'm thinking about, and I didn't research this candidly, but the indecent assault, that sounds a little bit different than the sexual assault term
It does.
we use.
It
And so
sounds
maybe
like a
this
different
is a
modifier.
this may have been a lesser intense thing that they charged him with because they thought they had more evidence for that. Maybe didn't feel like they had enough evidence to charge him with the full blown, most intense crime.
And lesser offense according to like the way that the criminal statutes are, right? I mean, at the end of the day, anything that even remotely resembles sexual assault or touching without permission is heinous and shouldn't happen.
Right, yeah. We're not minimizing it, right?
No,
right.
we are not minimizing. We're trying to describe legally how it's characterized.
Yeah. Basically means that the state felt like they had enough evidence to meet their burden of proof. With that offense, didn't think they had enough to hit whatever enhancement that would have carried with it a larger sentence. So, and his court cost that he was fined was about $70,000 would have been what his fine was. The charges were largely based on statements made by, and I don't know if she pronounces it Andrea or Andrea or whatever, but
you never know.
I'm going to say Andrea so we differentiate here.
Okay, that sounds good.
Made by Andrea Constand in 2004. So apparently in 2004, allegedly there was a sexual assault that was the whole foundation of this case. She made this report to police in Canada, and then this was forwarded on to the Pennsylvania authorities. 2005, she sues him for these injuries.
Sues Cosby.
Sues Cosby, thank you. And then here's where things get kind of crazy. And I still don't understand what the district attorney was doing here. But on February 17th, 2005, Montgomery County District Attorney, elected official, the guy in charge of supervising and leading all the prosecutors that work for that county, that prosecute crimes in Montgomery County, released a statement that went out to CNN and all sorts of other national news publications that charges would not be brought against Cosby at that time, citing, among other things, that Constand waited a year before bringing the allegations, continued to have contact with Cosby even after the allegations allegedly occurred. So he makes this statement to the public. And then in 2015, he makes that statement in the confines of the civil lawsuit, Constand suing Cosby. There's a deposition taken where he sits down and they ask him questions for hours upon hours. And he comes out and makes a couple statements about giving her Quaaludes and some other things.
Which Quaaludes are that thing in Wolf of Wall Street where they like got in the car and they think they're driving slow and then they get out and they see they wrecked their fancy car.
Yeah. So it's I don't know what type of, it's not
some
a
crazy
hallucinogenic,
drug.
but it has an effect on your brain and all that kind of stuff. There was some testimony in that. Well, those records were sealed. 2015, records were petitioned to be unsealed. And then the district attorney's office, at that point, the DA was Kevin Steele. He used a lot of that testimony as the basis to charge and indict Cosby in 2015 for this aggravated indecent assault. So Cosby appealed his conviction immediately upon the verdict. He was then, the conviction was then vacated and overturned. And I want to get to that. I want to talk about the right against self-incrimination, then we'll come back and analyze.
I like this. Do you want me to read it?
Yeah, sure.
Let's just read what the Fifth Amendment says. A little Constitution in the morning. All right, so the Fifth Amendment says, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, critical, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So that's a lot in there, but the clutch part is the phrase, nor shall be compelled in any criminal case to be a witness against himself.
Yeah, and you could spend, we spend in law school months talking about the Fifth Amendment in general.
So much time.
But we're going to focus on that part, self-incrimination. That's where the right against self-incrimination comes from. Now, when you read that text just by itself, we're going to get into all the other details, but to me, that just says okay, you can't be forced to be put on the stand and tell everybody what you did. It looks simple when you look at the actual.
It's deceptively simple. But what's funny, right? Miranda kind of plays out too, because Miranda is a result of a case back in the 70s applying the Fifth Amendment?
It was in 66, I think.
Okay.
I think I wrote, 66. Yep.
66. And that's wild. That's wild to me that Miranda took that long to develop.
Right. And actually, let's go ahead and jump down to that.
Let's talk about Miranda rights.
Miranda versus Arizona, case in 1966, came before the Supreme Court. And the idea was, before that, you could be arrested, and then the police officers could ask you questions, and if you said anything,
And then you're out of luck.
Yeah.
It gets used in court against you, and that was terrible.
Right.
And, people don't really know. Like, you get arrested, and you're freaked out. You're like, I'm innocent. I didn't do it. And then you start blabbering. Okay, well, now you've really dug yourself a hole. And things can be twisted out of context, and it's just bad news bears.
I mean, it's a stressful situation.
It is a stressful situation. I mean, I wouldn't know, but...
Right. I mean, I've watched a lot of video, interrogation videos, just in private practice and then in other, law school, things like that. And it's a very stressful situation. People react, everybody's been in stressful situations. You react differently to those times. And so there are plenty of times where people say things maybe they
wouldn't have otherwise said.
Yeah, and sometimes, so I don't want to get off on a huge tangent here, but some people say, well, if they said it, then maybe they didn't want to say it, but why does it really matter? Well,
it matters a lot.
Sometimes there's plenty of situations we've looked at a lot of cases, especially in law school, where people felt so pressured and so just coerced and just scared. They're willing to agree to anything because they've been promised that, if you'll just tell us what happened, we'll let you go. It's going to go easier for you, all that kind of stuff.
And that's, and that doesn't necessarily, let me rephrase that. If the cops say, you just tell us what happened, we'll let you go, that's usually a false promise, don't you think?
It is a false promise.
That's never going to happen.
Right.
And so there's so much psychological pressure and mind games that, and I don't mean this to be, pooping on the cops or anything, but I mean, when someone is arrested, there is a lot of psychology and mind games that go into the interrogation of the arrested individual.
Yeah.
And I understand the cops are just trying to do their job. But at the end of the day, I think people need to realize Miranda is important because you need to at least have a reminder that if you say things, it could be used against you. And if you're arrested and you don't get that warning pre-Miranda, your mind is probably all aflutter. And how are you going to even remember, keep my mouth shut?
Right. Well, and Justice Scalia, who's one of our famous Supreme Court justices.
R.I.P.
Yep, right. And he always talked about the whole idea behind the Fifth Amendment, the jurisprudence, the cases they see. They're trying to strike a balance between individual rights and the police officers' ability to do their job and ferry out justice and the truth and all those kinds of things.
And that's such a, I think, sensitive balance.
It's tough.
Because you have that equilibrium, you don't want to have it tilt one way or the other.
Right.
And it's really difficult.
Yeah. And a lot of people think these cases should be clean cut. They're not.
They're so messy.
Very gray area. Very, very gray. So what was born out of Miranda is something most people understand. They understand the Miranda rights. But the Supreme Court decided that safeguards should be put in place so that people will be advised of their right to remain silent and of their right to an attorney. The right to remain silent is the part that we're focused on because that's the right against self-incrimination. And there's been a lot of changes throughout the years about what has to be said, whether or not somebody can invoke the right and then revoke the right later, all sorts of stuff. But for purposes of today,
we'll keep it at surface level today.
Yeah, we will. And so the idea, to break it down, just to make sure this is clear, you have the right to remain silent. And the idea about self-incrimination is that they have to give you, or the idea about Miranda, is that the officers have to read you your rights when you are, one, when you've been detained by law enforcement and you're no longer free to leave, and two, you're involved in a custodial interrogation.
And what's a custodial interrogation?
And so that's the breakdown. Custodial means that you've been arrested, you can't leave. So usually there's handcuffs involved.
Usually.
Not always. But the idea is that it's not just a casual encounter where the officer's asking you a question on the street. It's that you've been pulled over by the police, or excuse me, not pulled over. You've been actually handcuffed, you've been detained, you've been put in jail. You are not free to leave. There's not like a situation where it's like, okay, officer, can I go now? It's like, no, you can't.
Well, is that something you should ask in that situation? If you're if you're feeling pressured, that the cops are pressuring you to talk to them and you don't want to say anything, can you say, am I free to leave?
Yes, I always advise that. Okay. Because if they tell you you're not free to leave, well, okay, then at that point, you know that you need to just shut up and be quiet.
Even if they don't read you your rights.
Even if they don't read your rights. Even if they don't. Now, you can challenge it later, but just better be on the safe side. The second prong of that is interrogation. So they actually have to, the way that you are protected is that if they are asking you questions about the crime and you solicit that information, you solicit self-incriminating information and they haven't read you your rights, okay, they violated Miranda.
And they can't use it. That's called fruit of the poisonous tree.
Fruit of the poisonous tree. Always love that illustrative analogy.
Makes me think of Snow White. Didn't she eat the apple and it was by the evil witch or something?
Yes. I mean, there's a biblical Genesis reference there too, probably.
Well, that too. There's also a Greco-Roman one, appellate discord.
Okay, yeah. Yeah.
Eventually started the whole Trojan War. Everyone thinks it was Helen. Helen was just a big step after the apple of discard in continuing the Trojan War.
Well, so we got a lot of analogies.
We do. We have all the analogies.
So, I want to. Well, actually, no. Let's stay on the Miranda thing. So, part of that, I get these questions a lot. If and there's some cases, and I didn't write them down because I just wanted to discuss the subject matter of them. But there's cases where officers have detained a person, put them in the backseat of the squad car, and they're driving to the police station, to the jailhouse, whatever. And they don't ask questions, but the person in the back, and again, this is the vivid case I remember, he voluntarily comes out and says, well, I buried the body here.
Dun, dun,
They go and find the body. Well, the Supreme Court ended up ruling he wasn't being interrogated.
Which is wild when you think about it. Because, I mean, what more evidence do you need, right? You would think, as a member of the general society, you're like, oh my gosh, this guy admits to knowing where the body is. Clearly, he must have at least assisted in the crime by burying it. Right. He has some sort of knowledge. If he didn't murder the person, then at least some lower level offense of assisting and abetting or something like aiding and abetting, excuse me.
Right.
But that's not the case.
Well, what the Supreme Court said was is that because you weren't being interrogated, you voluntarily gave that information, state can use it.
Yeah, which is wild.
Yeah.
Which is wild. Right. But had that situation been he was driving and the cops were saying, we know you buried the body, we know you did. And he's like, all right, you know I did it. It's over by the coconut palm tree.
Yeah.
Well, now they can't use it.
They can't use it if he had invoked his right to remain silent. If he had said, yes, I want to remain silent. So actually, let's go ahead and break that down too.
Okay.
The irony about your right to remain silent is that you actually have to verbally tell the cops you want to remain silent.
Which is wild, and I think a lot of people don't get it.
No sense.
It's very contradictory.
Yeah. So basically what happened was there were some cases where the cops repeatedly, do you want to remain silent? Do you want to remain silent? No answer, no answer. They kept asking questions, eventually got a confession. Confession was allowed to stay because they read him the rights. The person never said they wanted a lawyer or wanted to remain silent. And then they eventually answered. I have a problem with that because that's the whole coercion thing.
Mind games, psychological pressure.
Yeah. So everybody should know, if you want to invoke your right to not talk, you have to talk. But
let's just give you a speech to say, what should you say if you are reading Miranda rights and you're asked, do you want your right to remain silent respected or whatever? What should they say?
Well, what I would say is, as soon as because they'll read the Miranda rights and say, do you understand these rights? My next statement would be, yes, and I wish to remain silent, and I want to talk to a lawyer.
And then say nothing after that.
Don't say anything else.
Okay, perfect.
Because that's the other thing, is that the Supreme Court has also held that you can invoke your right to remain silent, verbally say it, and then later decide, you know what, actually, officer, I'll talk to you now.
Which is wild.
And so then, and then at that point, that revocation of your right to remain silent, they can use whatever you say. So it's one of those things that our citizens should be educated on it more because they don't know all these little details that most people don't know all these little details, with what you have to say, what you shouldn't say, and all that kind of stuff.
Which is wild because this is such a fundamental right for American citizens.
Right.
Well, I guess not. We can discuss that another time. This is just such a fundamental right in our justice system. And so to be unclear about it is really wild to me. But I think most of the general populace is unclear about it because it is not what you see on Law and Order.
Right.
So it's very confusing.
Well, and it's at the core of our justice system. I mean, it started in the 16th and 17th England where people were forced to take an oath that they would tell the truth about any and everything, which was then used for the Puritans in the New World, in America, to rat out their fellow colonists, friends. And so then, our founders said, we're not doing this anymore.
That's not cool, guys.
Right, because that's not, we're not allowed to do that. So we talked a little bit about the situations themselves, how it plays out in actual custodial interrogation. What custodial interrogation is, Miranda. Let's talk about where it actually applies, what situations. So the most obvious one is in a courtroom.
Obviously.
So this is part of the reason you rarely see a criminal defendant ever testify.
Because they're preserving their right to not incriminate themselves.
Right, because and the state can't force the defendant to testify.
Yes, that's another part of your right against self-incrimination. You don't have to get up on the stand and testify.
Because if you think about this, picture this in the scenario. If the state could force the person accused of robbery to go take the stand and ask them a bunch of questions about the incident and the allegations, what's the person going to say when they're asked questions about it?
I plead the fifth.
And what is that going to look like to the jury?
Extremely guilty.
Right. And so it makes sense that they can't force that to happen. Now, you touched on this earlier, so let's dive right into it. In a civil case,
yes,
it's different, isn't it?
It's so different.
Yeah. Have you ever been a part of that occurring, like actually in a trial?
No, I've never had any of my clients get up and say that. Usually my clients love to sing their story, and I was like, no, we have to curate,
rein
it in. Yeah, one of my favorite clients of all time. She's great. She's amazing, wonderful mom, wonderful client, so sweet, so generous. We spend hours and hours and hours, days woodshedding her, which is another word for witness preparation for those who don't know. She's doing great. She's awesome. I finally got her where she's not going to cry on the stand. We have her story. She gets up on the stand. 5 minutes in, what happens?
Wheels off.
Let me tell my story. And I was like, no, we don't need all the details. We just need the story we practice, which is true, but it's just kind of like a highlight reel.
Yeah.
And I was like, well, shoot.
I learned a long time ago, you can only do so much when it comes to that.
You can only do so much.
So when it comes to, when it comes to the idea of pleading the fifth in a civil case. So someone asks you a question while you're on the stand, while you're in a deposition about something that could potentially incriminate you. We have what's called the negative or the adverse inference that's allowed to be drawn. And this comes from this case in 1962, Baxter versus Palmigiano, I believe. The idea is that if someone's on the stand and they get asked a question, they say, well, I'd like to invoke my Fifth Amendment right, or on the advice of counsel, I'm not going to answer that question because of my Fifth Amendment right against self-incrimination. The fact finder, the jury, the judge is allowed to draw.
The judge when it's a bench trial.
When it's a bench trial. They're allowed to draw an adverse inference on that question. So what that means is if I say, Andrea,
why use me in this hypo?
Because you're sitting across from me.
No, use Lucy Lightweight or someone. Don't use me.
Let's say Dylan's on the stand.
Okay.
And actually, this happens a lot in family law cases.
There we go.
There's a parallel domestic violence charge going, and so then you have a family case hearing that happens before the criminal case has really gotten going yet. It hasn't been indicted. It hasn't been charged. And you've got the father up on the stand, and let's say his name's Dylan, and the mother's lawyer is asking a question, did you strike
Diana?
And he says, well, upon advice of counsel, I'd like to invoke my Fifth Amendment right to privilege.
But this is a civil situation.
Civil case. And so what has the Supreme Court said about that?
You can actually comment on the fact that this person is now invoking his Fifth Amendment right to remain silent. And so you can keep asking questions and you can comment on that. And it's not harassing the witness, which normally you would think it is, but it's not. And so now the jury or the judge, if it's a bench trial, can draw all sorts of adverse inferences, and they get all these thoughts of, wow, if he's not going to testify, shoot, he must be guilty, isn't he?
Yeah. And keep in mind, in this situation, we're talking about custody issues or whatever, because it's a family civil case.
And when I say guilty,
but the jury, they're going to think that.
They're going to think
guilty of this criminal offense. Therefore, I'm going to judge him for that when I'm talking about custody.
Even though they're not supposed to.
Well, that's actually this case says. So what they're allowed to do is, let's just take that exact question. Did you strike Diana? He says, I'd like to invoke my Fifth Amendment right. The judge actually has to give a jury instruction that says you are allowed to basically take that question, answer it in the most negative way possible for that defendant or for that respondent in the family case. So they can draw the conclusion that, okay, well, he invoked his Fifth Amendment right, then he did. They're allowed to do that. They actually are given an instruction on that.
Which is wild when you think about it.
Yeah. In those types of cases, it really makes the deck stacked against the person, because the innocent until proven guilty side of the criminal case, it doesn't really matter in the family law setting, which is I can go off on a tangent on that
another day,
because it makes it very difficult, right?
It does. Yes, it does.
So this also, the right against self-incrimination applies in congressional hearings. We've seen that in some of these, sometimes when people are called to Capitol Hill to testify about some atrocity that's happened. They invoke their Fifth Amendment right, and that happens. We talked about custodial interrogations when the police arrest you and asking you questions about all this. There is an exception
I love a good exception.
And this is really how we're going to segue into the Cosby case. This case, Castigar versus United States, 1972. The government can force somebody to testify if they grant them immunity from prosecution for that crime.
That's so interesting. So do you normally see this in a drug kingpin situation?
You see it a lot in drug trafficking situations. Okay. Yes. So yes, drug kingpin. Yes. So you get, in the federal case, you get a federal drug charge, and we work out a deal where they get, and I won't go into all the details of it, but you basically get a plea deal that we're going to plead guilty. We're agreeing to plead guilty. In exchange for that, we're going to testify and give you more information. And you can get some 5K1 points and things that'll help move your sentencing guidelines up so that they're...
And we've discussed sentencing guidelines in a previous episode, so if anyone's interested in that, they can hop a few episodes back.
So usually in exchange for that plea and that, you giving information, they're going to, one, help you get a lower sentence, and two, grant you immunity from prosecuting you further for anything else that you say. And that's a big kicker. That's one of those things that you have to negotiate in that plea deal when you're doing that.
And now how does that play into double jeopardy, right? Because that was another portion of the Fifth Amendment that we read, is that you can't be tried for the same offense twice. And I'm paraphrasing, obviously.
Right. Well, on the plea side, double jeopardy doesn't really attach there.
Yeah, well,
because you've got the immunity. You got the immunity. Now, let's just talk about Cosby, because that's part of the issue that came up here. Jeopardy attaches in a criminal case when the jury is impaneled.
Which means that's when the jury comes in, sits down, and is ready to start.
After voir dire.
Yeah, after voir dire. So we're not, so I guess a lot of people can get confused about this, right? So you have the panel, right? And that's where you have all these people come in, you have your numbers, and you start voir dire, which is the jury selection process.
Right. So you got, say like in a felony trial, you've got 72 potential jurors sitting in the gallery there that you're going to start asking questions to.
And then through voir dire, you whittle it down to what, 12, 14?
12. And then if you have alternates.
Yeah, just in my one criminal case, I think we had 2 alternates. So I think maybe it was just one. So we had 13 or 14 people on the jury, but the alternates didn't know that they were the alternates.
Oh, okay. That's interesting.
Yeah. Well, the judge was like, no, I want everyone to pay attention.
Yeah.
And if you're not, because you don't know if you're the alternate. And actually that was really useful because one person actually literally slept through critical parts of testimony.
Oh, I've seen that happen.
And so the judge at the end was like, we're booting juror number X out, alternate. You were the alternate, now you're in.
Yeah.
But the alternate paid attention the whole time.
Yeah. Well, so I got to tell you, I've seen that happen before, and I found a reason to approach the stand and bump the jury box so I can get the person awake again.
You know what's going to be really fun? Like after you get married is you can bang a wedding ring.
Yeah, that's smart.
Spencer loves to bang the wedding ring.
Smart.
Yeah, so now you'll have
about that.
There you go. You'll have a new way to wake the jury up.
I love that. That's awesome. So after you whittle them down, once the 12 or the 14, if you got alternates, are put actually physically in the box, and then they're given their instructions, they've now been what's called impaneled. And at that point, for purposes of the Fifth Amendment, jeopardy attaches. And so, unless there's like a mistrial or something like that, if something happens where there's an appeal later, like what we have in Cosby, you can't try that person again, except for some exceptions that go to that. So you can't. So for example, Bill Cosby.
Let's go back to Cosby.
Charged with the. Let me make sure I get the term right again.
Indecent sexual assault.
Aggravated indecent assault.
There we go.
So he's charged with that. The jury's impaneled. He's convicted. Then he appeals. Now, the foundation or the grounds for the appeal go back to that statement made by the DA in 2005, where he says to everybody across the country that Montgomery County will not press charges. They will not go after him. So then what the appellate court says is that, well, they go into it and they talk about, okay, prior to testifying in the Constand civil case, he was in deposition, he relied on that promise made by the district attorney Castor that they
Good old reliance.
That they will not prosecute him. So at that point, you've got this immunity idea that came out of this Castellagard case that, okay, we're not going to prosecute you. We're saying we're not going to. And so he relied on that. He went and said what he said in his depositions, which were then sealed and reopened.
Which is a big, big problem because we were just discussing immunity as it relates to the Fifth Amendment.
Right. And so you can't, that's one of those things where the court's holding the state to its word, because if you think about that, you can apply this in a lot of different situations. If the state tells you something and then they're really lying that, okay, we're not going to prosecute you, we're just trying to find this other person. You tell us this information, okay, great, cool. Now we're going to stack another 3 or 4 charges on you.
Yeah.
Well, that cuts against this whole idea and the whole
That cuts against the entire idea. And I mean, think about this, right? So what if you're, Debbie the soccer mom, right? And you unwittingly get pulled in to some sort of pot smuggling operation, and you didn't realize your little boy, Johnny, is the little drug kingpin at his middle school, and he's selling pot. And then she gets pulled over, they find pot in the car, blah, blah, blah. She tries to take the fall for her son because she's a good mom, and she thinks that's what good moms do. And they say, oh, we're not going to prosecute you if you tell us.
Where did he buy it?
Where did he buy it from? And she's like, I think he bought it from Kyle because I see them exchange packages at school, but I'm not sure. And then they go, and when they can't get Kyle, they're like, oh, okay, well, we'll take Debbie. And they stack tons of charges on her.
Yeah.
Well, that's not fair to Debbie.
Right.
Right. And it's a violation of her Fifth Amendment right. And so in that situation, I think she's a little bit more of a sympathetic figure.
Well, and think about it, and I'll even, this is unique and weird for me, I'll even argue it from the state side here.
Wow. Who are you?
That frustrates the process too, because if we know that you can make a promise and then take it back, well, then I'm going to tell my client, no, don't tell them anything. We're not cooperating. You guys can figure out who Kyle is on your own, and that doesn't help the investigation.
No,
trying
not
to find
at all.
the bad guys,
It slows down the investigation. It utilizes more and more tax dollars and public funds, and we don't want that.
Right.
We have, I think there's case law that says this over and over again, that the right to having an efficient court system, that's a factor that's considered in a lot of different situations, right?
Yeah.
Whether it be sanctioning because someone failed to abide by the appropriate discovery rules in a civil trial, or because they're messing with the Fifth Amendment. At the end of the day, we need to have an efficient court system.
Right. Absolutely. Yeah, absolutely. And so going back to Cosby, one of the most interesting things to me about this was that the court found that even though there was no written agreement not to prosecute, the public nature of that statement, we're not going to prosecute, that was sent to CNN and all these other news stations, led to Cosby's subsequent testimony in the civil trial that he, could be compelled to testify in that trial had he known that there was still the possibility of him being prosecuted, and then he still said those things. Okay, well, that's different. Probably would have invoked his Fifth Amendment right, though, in that civil case. So it's interesting that it played out that way when it was just like a public statement. And that's really, I haven't heard of that before. So that's a unique.
Yeah, I haven't either, but
that's very unique for the Fifth Amendment as far as that's concerned. And so the big debate from here, and I'll read a quote from Kevin Steele, the current DA that was part of this prosecution. He said Cosby was released on a procedural issue that is irrelevant to the facts of the crime, and he hoped that Cosby's release would not discourage crime victims from reporting sexual assaults because no one is above the law, including those who are rich, famous, and powerful. On the other hand, and this is that was the quote, on the other hand, there's commentary that a lot of criminal defense lawyers are arguing this isn't a procedural technicality, it's a constitutional right. And that is my argument. I think one of my big issues on this whole situation is, okay, if you've got all these stories, because there's been a lot of women come out about what happened with Cosby. And I don't know, I'm not going to get into because I don't know enough about it, about why people didn't come forward, all that stuff. That I know that there's a lot of psychological things that go into that, and emotional trauma and everything like that.
A lot of shame, a lot of fear, a lot of fear about what's going to happen to their career. They'll be branded. And a lot of women who come forward, right, who've been victimized are very wrongly treated by the press or treated by their society or their church as sluts or outcasts or hoes, which is awful because they're none of these things. They've been victimized and now they're being brave and going forward. Yeah. But those are the fears that they face.
Right. And so I just want to be clear, like I'm not commentating on that. What I do take issue with is the DA, Kevin Steele, you're basing the entirety of this heinous crime and the prosecution of this crime from deposition transcript excerpts that have been sealed and were taken in 2004, 2005, and you're basing the entire case on that. Well, that's problematic, one, because of this issue we're dealing with, the reason it got flipped. But two, I mean, I just got to imagine there's some more evidence out there for them to go gather and try to put together to make this case stronger.
I'm sure there was, and I'm sure that, look, people who commit crimes of violence against women, they don't just do it once.
Right.
They're typically, as we discussed with Tara Avance when she came onto the podcast, who's an assistant DA, and Michelle Simpson-Teagle. Usually people who assault women, whether it's battery or sexual assault, they have a habit.
Yeah.
They do this multiple times. It's never just once.
Right.
And so because of that, I'm sure, right, and we already had other women come forward saying that Cosby did something similar to them.
Yeah.
And so there were opportunities and there was evidence to be had the prosecutor spent more time building the case.
And the problem is, as we know, when you're prosecuting or when you're even in a civil lawsuit, you put everything you can, every piece of evidence, every different charge or cause of action, if you're suing somebody, you stack all those things in there so you got one shot at this thing. And the reason you do that is because if you're only basing your prosecution off of one thing, and that one thing is then found to be flawed at the appellate court level like it was here, well, the conviction's overturned because they can say sometimes if you've got a whole bunch of other things in there, you can say, okay, well, this one thing, this shouldn't have been allowed in, but everything else was so heavy against them, guess what? The conviction stays. Well, if you just have one theory here and that gets flipped, well, guess
Then
what?
you're in trouble.
Conviction's vacated, and like we talked about earlier, jeopardy's attached, and so they can't prosecute them again.
And so, I mean, at the end of the day, that's just how our justice system works, and it's there to protect you. And unfortunately, you know, this system, or excuse me, this principle is illustrated by an individual who allegedly committed a really heinous crime like Cosby, and it sucks that someone like that is getting away with it. But at the end of the day, this right is here to protect the innocent as well.
Right.
And so that right is not negotiable in my mind.
Yeah, it is. It's not negotiable. And I go back, there's a scene in the movie Lincoln Lawyer where...
Oh, I love that movie.
And it's the scene, he's getting off the elevator and the detective is arguing with him or giving him a hard time about this one guy he defended and got off because the guy was a serial killer, all this kind of stuff.
Jeez, yeah.
And Matthew McConaughey goes on and says, well, actually what happened was the DA stacked a bunch of extra charges that they couldn't get solved on my guy. We were able to prove that, and so my guy walked. So he was, and I'm not going to use his language in there, but he basically says it's the DA's fault. And this may be not a popular opinion, but my issue here is they should have done a better job prosecuting this guy, because if he did these things, and it seems sitting here, and this is, I'm being non-lawyer here, like it looks like he probably did. I mean,
it sounds
it's
like
highly likely that he did. Do a better job. Make sure you know how this stuff works. You do this on a day-to-day basis. Do a better job. Stack the deck against him so that even if you're just using something that gets flipped on appeal, it sticks and he stays in jail.
Yeah. The state needs to be held to their burden.
They do.
So
they do. And so I think that's one message that I think gets missed, is that we need our prosecutors to do, we all want our prosecutors to do a good job. We want our detectives and our police officers to do a good job.
Absolutely.
So the people that are committing the crimes, those convictions stick.
Absolutely.
Yeah. We're never a fan of people getting off because they're guilty. No. We're a fan of protecting the rights that end up, protecting the innocent as well.
And on that note, final words of wisdom?
Make sure, I think the final words of wisdom, we want the real big takeaway here is, if you're arrested, if you think you're being arrested, if you're being questioned by police, ask them, are you free to go? If you are detained, if they say you are not, then you tell them, I don't want to talk anymore and I want to speak to a lawyer. If you're arrested, same thing. They'll read you your rights, tell them, I don't want to talk anymore, I want to speak to a lawyer. One last little thing I will tell you too is that if they arrest you and don't read you your rights and then don't ask you any questions, some people think, oh, well, they didn't Mirandize me, so the crime's not going to stick. Doesn't work that way. Miranda only works with the evidence they procure after they've arrested you. So that's a myth.
Well, everyone, thank you so much for joining us on this episode of #Lawyered, where we dove into the Cosby trial. And we'll see you next time.
Know your rights.
Hey y'all, don't go. We have closing arguments coming up for you in just a second. But before you listen, make sure to rate, review, and subscribe to the podcast if you got any value from today's episode. And please share the podcast with others. And if you want to interact with Austin or me, or tell us what you want to hear next, you can find me on Instagram at andrea.s.turner, Austin at The Dallas Lawyer spelled out, or the podcast #Lawyered spelled out. Look forward to hearing from you.
Tiger King is back, y'all. Joe Exotic's murder for hire conviction is upheld by the 10th Circuit Court of Appeals, and he remains caged for the time being. Joseph Maldonado Passage, Joe Exotic, Tiger King, was convicted on charges of murder for hire of Carol Baskin in 2019 in Oklahoma federal court. The Tiger King appealed the conviction on numerous grounds, but the 10th Circuit upheld it, affirming the trial court's rulings below. This case was sent back down to the trial court for a calculation error that was made on the sentencing guidelines, but the conviction is going to stand, and the Tiger King will again remain caged for the time being.